and the Deputy President of the Republic of Kenya. That Siopan Tuya is an agent of the presidency. Your Lordship, one of the issues that was before the impeachment was that the Deputy President, the petitioner herein, indicated that Kenya is a shareholding country. There are shareholding agreements before you, and that positions either in parastatals or corporations were to be shared in accordance to that share agreement.
But that is the reason why his client got impeached. That is not anything that is before you for determination. That is the reason he was impeached.
To be given an opportunity to respond. Even if you are itching, Mr. Nyamondi, take your call. Your Lordship, it is my client's submissions that Florence Auma Oluoch may have been a beneficiary of that shareholding. Your Lordship, finally, Your Lordship, we have just a minute.
It is extremely unfair and unjust, especially for an advocate to mislead or what you have seen to play to the gallery. Can you read paragraph 12 of the affidavit? He will so that he does. No. Yes. Let's hear it from him, where he says that the said board is chaired by the president, who has. So can you kindly do it properly so that you don't?
I'm sorry, I'm not. Excuse me. No, excuse me. No.
Hold on.
Your honors, your leadership, and my lords, they will have time, as you said, to respond and say all these things. If he's saying nonsense, they will stand up and say so. But this constant interruption is intended to derail this hearing. Let them respond when their time comes. Yes.
And we abhor the condescending nature of the respondents. Everybody here has been instructed by a client either to speak sense or nonsense. So that being the case, the condescending attitude is completely objectionable, and everybody should take their seat and use their time with sense. If sense can only come from them, they do it during their time.
Thank you very much. Sir, can I finish what
my
I
Lord,
say?
may I be protected to urge my application and the respondents be granted opportunity to respond?
Finish what I was saying.
You will have your time.
I know I will have
to
my
respond.
time. But please, this is the application being presented. Let's not have a thing.
It has been served upon you.
You will respond.
Just permit me to say one thing. Just one thing.
Your Honor, if I'm allowed to just say something.
Just a minute, just a minute,
Let applicants finish their case and then people will respond. Because this interjections is just going to affect the conduct of the proceedings. It's very unfair. Let everybody have a chance. Each person has 10 minutes, others have 5 minutes. Let them utilize their time. But these objections in between is unfair and it's affecting the flow.
That's the fact. Come to court and say that.
My Lord, this is what I want to say.
Order. Can you have some order? Can you please have some order? Have you may proceed.
A judge is first, an advocate, second, an advocate. They are all here advocates. My plea is we conduct these proceedings in an orderly manner. As Professor Gidu Mujai used to remind us when we were in school, to be an advocate, you are a superior mortal. Can we just be slightly superior and deal with this thing in an intelligent way?
Ms. Handagwa, use your remaining time to conclude.
Well, I am most obliged, Lordship. It may be noted that, Your Lordship, that the chair of this board is directly appointed by the president, the six respondents in this case. Your Lordship, may I submit again that the perception out there is that this bench has been constituted for a particular purpose, and that the bench is just a mere conveyor belt, and that the parties herein will not have the chances to have justice of their case being dispensed. Your Lordship, I have annexed a tweet by Senior Counsel Ahmed Nasir, annexed in our affidavit at paragraph 12, and I would wish to read that tweet, Your Lordship. Ahmed Nasir, Your Lordship, is a senior member of this bar, a senior counsel, and Your Lordship, here it goes. The conservatory orders will be discharged by the 3-judge bench, latest by next week, if not by Friday. Even as we approach you, Your Lordship, the perception out there is that this bench is part of the conspiracy.
My Lord, may I object to that? Ahmed Nasir is not the law.
Your Lordship.
He speaks not to the law. Ahmed Nasir has also an affidavit. He is not a witness, my Lord. How does Ahmed Nasir, and we have 64 senior counsel, how does Ahmed Nasir, how can his tweet inform submission before this court?
May I answer that, Your Lordship, to the good professor, that we are speaking about perception. The standard of a bystander, the reasonable man, a fair-minded man in the status and the character of a senior counsel, Ahmed Nasir says, and the president's lawyer says, we cannot receive justice. That is the standard.
My Lord, Ahmed Nasir says that this court will quash the impeachment of Rigathi. No, but the point is, he then speaks in your favor.
Yes.
Pick that line.
Let him respond. You will not teach me how to submit. You will pick the line that you so wish. For me, I am saying, Your Lordship, that the perception out there is that this bench has been constituted as a conveyor belt. Finally, Your Lordship, this court will remember that on the 16th of October, we moved the court for a mention on the 18th. The court declined to grant that mention and slated our file to be mentioned on the 29th of October. But when they were moved by parties in these proceedings, the court was generous and gracious enough even to sit on a weekend, to sit on a Saturday. Noting that we were before you, you slated our matter for the 29th and never saw the urgency. Your Lordship, how can a fair bystander be convinced that this court will dispense with substantive justice? How can it be said that this court is impartial? Your Lordship, the question of a spouse being linked to a judge, as indicated by Rules 47, is of paramount importance and something that cannot be ignored. Why didn't the court disclose to us? Why did the court conceal? If the court can conceal such kind of apparent evidence, what else is it capable of concealing? Your Lordship, permit me to indicate that in our affidavit that would wish to expunge paragraph paragraph 16 of our affidavit, supporting affidavit, will not rely on it, and paragraph 10 of the same affidavit will not rely on the same. But the standard, Your Lordship, is that of a bystander. Ahmed Nasir spoke, and he has a following of over 1 million on his Twitter handle. That is, the perception has been created to the Kenyans that this bench, 1, is a conveyor belt, 2, it is considered for a particular mission, 3, it's part of the conspiracy. Your Lordship, we urge you to uphold our application and grant the prayers sought. Your Lordship, my learned friend Mr. Masharia will highlight on the authority, with the authority in support of my submissions and those of Kibe.
Sorry, just a slight clarification on the expansion. Paragraphs 10 and 16, if I heard properly.
Yes, that's correct.
Of the supporting affidavit.
That's correct.
I don't know whether we can do that through oral submissions. You cannot expunge a paragraph from an affidavit as it is evidence before the court, and it has to be considered, it has to be challenged in all ways. Number two, if you expunge paragraph 16...
Can you cover it in your response, please?
I may, but if you expunge 16, I have a problem with that. There is no application before you. If you expunge paragraph 16 from the affidavit, there is no application as being urged before you. So we need all this clarification. Let's not take things lightly.
Yes, Your Lordship, yes, it is true that the paragraph that I seek to expunge is paragraph 16.